Yogah Karmasu Kaushalam.
Namaskar, dear all participants. Now, in our next session, here we have Dr. Sanjay Raja, sir. And he is an associate professor at Maniklal Nanavati Law College, GLS. And he has trained more than 75,000 students, teachers, and professionals on transformative learning system. And he has written and published 3 books. One was selected in Vache Gujarat project also. So here we have the Dr. Sanjay Raja, sir. And dear all participants, so now we have Dr. Sanjay Raja, sir. Over to you, sir.
Thank you. So thank you, Rishibai, for introducing me. I don't know why, but somehow I like my name very much. So I always like to introduce myself. I'm Sanjay Raja. Basically, I work with Maniklal Nanavati Law College as an associate professor. Very good afternoon to all. I think there are almost 25 participants are there, professors are there. See, today we are going to discuss about the social legal aspect of pandemic. There are 3 words which are very important so far as this session is concerned. So there are 3 words which are very important. One is pandemic, epidemic, and endemic. Now, if we understand the terminology of this, especially these 2 words, epidemic and pandemic. Epidemic is somewhat regional specific. As I said, epidemic is a regional specific, while if any disease which is pan-India or which is we may call international issue, then it's termed as a pandemic. Now there are some legal concerns associated with this issue also. So, for example, if some couple is going on a date and it's a Valentine Day, and some government officer approach that person, they are going by their own car, and some government officer approach that person, and if he says, I need your car, just give me your car, I'm a government officer, I need your car for a specific purpose. Now there are 2 questions associated with this. Like in this pandemic era, so many issues, so many conflicts among the government officer and some citizens of India happened during this time. Like government took so many hotels and they converted that hotels into the hospital. They took charge of some private hospitals also. They have put some restrictions on like marriage ceremonies and they notified some curfew areas. So my question is that, is there any particular demarcation among personal liberty and government's power? So before we discuss that, let me explain what kind of rights have been given by Indian Constitution. Rishibai, I got it. Exactly. Thank you. So what kind of rights we have through which are confirmed by the Constitution of India? Personal liberties rights are confirmed by the Constitution of India. Now the question is, at what extent government can put restriction on these personal rights, on these personal issues? Let me give some few examples of that. Say, for example, number of marriages. If anyone, say for example, he is a Hindu person, want to marry with two girls. Whether, my question is that whether it is his personal issue or it is his public issue. कोई इंसान अगर दो लड़की के साथ शादी करना चाहता है, that three person are major. So whether it is his personal issue or it's a private issue. And if that person is a Hindu, all of three. Somebody has raised a hand. Is there any question? Padmanabha sir has some question. You may go ahead, sir. Okay, fine. So again, if someone want to marry second time or third time, and his previous marriage are not dissolved, what I want to ask you with that issue, whether that incident, that issue is a personal thing or it's a private or it's a public thing.
Sir, I have meant comment it is a public issue because you said that the person is Hindu and he is moving or affairing with to another lady. So
No, he want to marry,
without,
not affairing, but he want to marry with two ladies.
but if he is a Hindu person, then as per the Hindu code or whatever the rules and regulation, he must have particularly divorce before that.
So I'm not asking you what is the situation as per the law. I'm asking that whatever clothes I want to wear, that is my personal issue, right?
Okay.
Whom to marry is my personal issue.
Yeah.
Right? What to eat, what not to eat, it's my personal issue.
Yes.
So then, number of marriages, why it's a public issue? I'm not asking this question. What is according to law? I know. According to law, Hindu male person can marry maximum with one person.
One person, yes.
Right? That is according to law. My question is
I
not
thought only regarding the particularly as per law.
No, not as per law. In general,
Okay.
Whether
Okay,
it's
sir.
how many number of marriages, purely whether it's a public issue or it's a personal matter.
Then it is a personal matter. It is personal.
It's a
matter.
personal matter. But
Right.
in a personal matter, so what I want to convey, law is interfering in the personal matter, right?
Right.
Say for example, Gujarat is a prohibited state. I say for example, I have a money. I just want to drink at my home. I don't want to. I mean, I want to consume liquor in my home. I do not want to disturb anyone.
Anyone.
Whether it is my personal issue or it's a public issue.
It is a personal issue.
Personal issue.
Personal issue, sir.
Now there is a law, prohibition law in Gujarat, and liquor consumption in Gujarat is an offense, right?
Right.
So what I want to convey is that there are some personal issues. Now government or our legislator has made some laws to restrict our personal liberty, and that happened in in epidemic and pandemic time also, right? So before we discuss, okay, what is the exact demarcation line where framers of law or our like government or our legal system can put a reasonable restrictions on. Before we discuss that, let me tell you something about what kind of rights we are having so far as Indian Constitution is concerned, right? So part 3 of the Indian Constitution is relating to fundamental rights. Now there are so many starts from article 25 to article 35. There are so many fundamental rights are given to the cities available to the citizens of India, and some rights are available to even non-citizens of India. Like the most important rights are right to have a personal liberty, right to life, right to freedom of speech and expression, freedom of trade and profession, right? These are some basic fundamental rights. Now in this epidemic area, there are so many conflicts happen among the citizens and the government officers. Citizens argued that, oh, it's our fundamental right, you cannot put restrictions on that, right? Say for example, in curfew time, nobody can move out of their home. So what about their livelihood? There are so many person who can uh, like they are daily wages, right? So what about their livelihood? What about their employment? So the thing is that there were some conflicts. It's still there. So let me discuss this issue 360 degree. I'll give you some examples of that. Okay, what kind of restrictions uh, even Constitution of India recognize that restriction, but it must pass the test of the reasonableness. Uh, Let me give you 2 3 example of cases. Say for example, there is a very popular case of Bijoy Emmanuel versus State of Kerala. I repeat, Bijoy Emmanuel versus State of Kerala. Now, what happened in that case? It's relating to right of speech and expression, but you may understand the demarcation line uh, and the thing what is actually reasonable restriction. There were two kids who were studying in a missionary school in Kerala, and before commencement of any classes, they usually stand up and recite the national anthem. But there are two uh, students who never recite. They usually stand up in the classroom, but they never recite the national anthem. Now, once a teacher asked them, okay, why you are not reciting uh, national anthems? Then they argued, okay, we are following a religion called Jehovah religion, and according to our religion, we cannot worship anyone else uh, except Jesus Christ. So teacher explained them, okay, it's not about worshipping anyone. It's about giving respect to the nation. But they were not convinced. Uh, so they called their parents and said, okay, see, this is the issue, and you must uh, ask your child to participate. Matter went to the so they they were restricted that to students from the school. They were restricted that students, and matter went to the Kerala High Court. Kerala High Court confirmed, yes, you have your own personal liberty, but when there is a question of nation, you do not enjoy that right. Then matter went to the Supreme Court. Supreme Court says in right of speech and expression, inherent right to keep silence, it's always there. So Supreme Court has widely explained what is liberty, what is personal liberty. Now in this pandemic area, government took possession of so many hotels, they took possession of so many vehicles. They have enacted some laws also, like Disaster Management Act, uh, Epidemic and Pandemic Act. They made some through notification. Uh, they have increased the punishment of injury or grievous injury if attack is made on any medical personnel, right? So whether now the question is that whether government enjoy all these rights according to Indian Constitution. So my answer is yes. In a rarest of rare condition, government has all this right. Government enjoy all this right to put reasonable restrictions. But that reasonable restriction must pass the test of reasonableness. Now, what is reasonableness? It may vary. It's not like that citizen of any citizen of India cannot challenge these things in the court of law. But the government must prove that whatever the restriction we have put to deal with this pandemic situation, it is reasonable. That reasonable test of that reasonableness can be checked by the High Court or the Supreme Court. Lower courts do not have jurisdiction according to Disaster Management Act. But High Court or Supreme Court can always check the whether it's reasonable or not. I'll give you some few example of cases. It's not purely on pandemic, but you may understand what is reasonable and what is not reasonable. So, for example, there is a sampradaya called Aghori Sampradaya, and on a particular day, they usually take some lethal weapons with them, and they are popularly known as a Naga Bawas, and they used to conduct one julus, one uh, ritual assembly, uh, one march on the particular day. I'm talking about the city of Calcutta. So a very chaotic situation used to happen there. So Commissioner of Calcutta put ban on this kind of julus. So they went to the court and argued that it's our fundamental right of speech and expression, and it's also our religious liberty. A commissioner cannot put restriction on this kind of issues. So matter went to the Supreme Court, and Supreme Court says, see, we have all the regards to the uh, your personal liberties or your personal freedom, but commissioner can no fundamental right is an absolute right. It always comes with reasonable restrictions. It may varies from circumstances to circumstances. So in a particular circumstance, state can put reasonable restriction on your fundamental rights also. So this is one aspect. Now the second thing relating to pandemic, that we have observed that so many laws are made by the central government. Now here one question arises, whether health issue it's in the purview of state or it's in the purview of center. So let me tell you, it's in the state list. It's in the state list. There are three kinds of lists which empower state or center to enact the laws on that area. Like one is a union list, one is a state list, and third one is a concurrent list. So health is a subject of the state list. But due to this pandemic situation, central government has power to enact the laws in a special situation. Sometimes, if some states, more than two or more states, request the central government to enact the laws or any regulation on that, it's there in the Indian Constitution also. Now, one basic thing came into the picture during this time. Government has announced so many rules, regulation relating to this. And sometime, like with police person, if they are stopping someone in that curfew area, they usually argue in a very simple manner कि सर हमें तो पता ही नहीं था कि ऐसा कुछ law है. Now my question is that can anyone argue on this track, like I do not know about this rule or this regulation. Say for example, there is a law relating to smoking in a public places. So can anyone argue that I was in USA when this law was enacted and passed, notification was published, and just day before yesterday I came from USA, so I do not know about this law. My question is that can anyone argue like this, and whether it's a valid argument?
I think, sir, it's not a valid argument. Merely saying I don't know about this law, because if you are smoking at the public place, so you are your surrounding people are becoming the passive smoker. So you will be sick along with others. You get sick.
That is true, but that person was USA when this law was enacted and was published. So can that particular person argue that, okay, see, I was in USA, you can see my passport also. Just day before yesterday I came to India, and out of that airport I started smoking. So when I left for USA, there was there was no law on smoking in public places. So can in a particular situation anyone can argue this?
If person is argue like this, I think it's wrong, and person should be aware of the law where he is going, and it is his duty, moral duty, personal duty, you can say. So you must know about it, whether it is law is allowing here to smoke in public place.
So absolutely right, sir. Absolutely right. Can anyone presume how many laws are there in India to deal with different matters? A wild guess. See, there are more than 10,000, 12,000 laws there in India. So there is a basic presumption of law that every citizen of India knows each and every law of India. So the question is that ignorance of law, as you rightly said, ignorance of law is no excuse. Say for example, if X kill Y, and if he argued, आप में से काफी लोग सोचते होंगे कि अरे ऐसा आर्ग्यू कौन करेगा, but this happened in the history. If someone argued that killing a person is an offense under Indian Penal Code, I don't know that, or government never informed me that this kind of law is in action. So this argument cannot be a valid argument, because there is a basic presumption of uh, law that every citizen of India knows each and every uh, aspect, each and every law of India. So ignorance of law is not an excuse, right?
Yes.
Now there are 2-3 more issues which were noticed uh, in this uh, pandemic time. There were some conflicts relating to privacy also. Almost around 25 years before, uh, Supreme Court has dealt with a case. That case is known as a X versus Y. Why they have kept the name X versus Y? Because there was uh, one person who was suffering from HIV. Now, what happened in that case? Uh, that hospital authority informed uh, his family members, and especially his in-laws, about his disease. He was about to get married, and matter went to the Supreme Court relating to that person argued that it's my right of privacy confirmed by the, and it's my fundamental right confirmed by the Indian Constitution. So uh, hospital authority do not have any right to declare that information. So if you have observed previously, all the newspaper usually published uh, in the newspaper, okay, these are the uh, passions of COVID-19, right? Even corporation or local bodies like nagarpalikas and all, they usually uh, put paste one poster of the patient's home, on the patient's home, that by that poster they want to convey that, okay, anyone, any person from this family or the entire family are suffering from the COVID-19. So the rest of the people can take uh, precaution or measures. So there were some incidents where some citizens argued that, okay, see, look, it's my right of privacy and government cannot do like this. So Supreme Court has given a very clear verdict in the case of X versus Y, that when there is a question of public health, public at large, it's a question of health or public at large, we cannot protect anyone's private right. Now you enjoy the right of privacy, but that privacy cannot be protected at the cost of public at large. So that is the thing. One more issue came during the during this pandemic time, that there are so many actions of the government where in the question. Say for example, if government puts some restriction on the movement, on the personal liberty, especially freedom of movement, and because of that movement, if someone occurs a very uh, encounter very heavy loss because of this kind of restrictions, like theaters, like clubs. So can that personal parties sue government of India or state government for their damages or for their compensation? See, recently Supreme Court, Union government has declared that any uh, family member of a deceased person due to COVID-19 will get 2 lakhs rupees of ex gratia aid, right? So apart from that, there were so many losses of businessmen and like industrialist or the owner of theaters or owner of club. So my question is that whether they can claim that damages or loss to the government of India.
I think it should first government should have to prepare the lab. Sorry, a law.
Hmm.
Then that case, the victim relatives can, deceased person's relative can claim for compensation or ex gratia. That I think.
See, before we discuss this thing, let me explain what is the difference among the compensation mechanism here in India and compensation mechanism we observe in developed country like USA. There was one incident where a priest, a priest from a Swaminarayan Sampradaya visited one. Uh, he was in USA, and uh, there was one disciple of that priest. So he asked his friend who was running a motel there in USA. Uh, हम लोग कभी नहीं बोलते कि ये साधु महाराज आए हैं तो उनके चरण आपके घर में अगर आए या आपकी जगह पे आए तो काफी अच्छा रहेगा. So that person agreed, and that priest has visited his motel. Now on the reception counter, there was a black woman was sitting there. So that owner of that motel has requested. Uh, he asked that lady, please you uh, go in the side room. So she asked why. So he explained. Usually, any priest from this Swaminarayan Sampradaya, they usually do not meet with women. So to avoid that situation, he requested to go somewhere. So she felt very insulted, and she filed a suit against that person, and she won that case. She won on the basis of discrimination between men and women, and that person uh, has to give a very huge amount to that lady. There was one very popular uh, incident relating to McDonald's coffee. Uh, See, if anyone can, there are so many outlets of McDonald's where you can, uh, one may order from a window. It's like a window shopping. So from one window you may order the snacks or coffee, and from the second window you may get that. Now that lady uh, ordered a hot coffee, and of course it's too hot, and she was that time driving a car. So some uh, coffee fell on her legs, and her legs were burnt. So she filed a suit against a compensation suit against that uh, against the McDonald's, that I ordered a reasonable hot coffee and it was too hot, and there was no dangerous sign. There was no notice printed on the magnolia on the coffee cup, so I must be compensated. And against that lady won the case. So what I want to convey is that compensation mechanism here in India is in a very primary stage. It's yet to develop. Uh, so overall, there is a saying in a law that king can do no wrong. King can do no wrong. So looking for the welfare of public, if in any case government has violated rights of any private person, thou government is not liable for that because of two things. One is that it's now partially accepted thing. It requires a very long discussion. But one thing is that king can do no wrong. So king is not king means now parliament. So parliament has not or government has not liable to pay the compensation because they want because of their restriction if somebody has suffered some loss, right? And because of its in the welfare of the public at large, the government cannot be held liable. So these are some issues, some things relating to pandemic time, especially how one can. See, it's a big issue of keeping balance among personal liberty and
Hello, excuse me, sir.
yes,
Myself, Dr. Krishna Prakash,
G.
Assistant Professor Biotechnology Department, Central University of South Bihar.
Yes, sir.
So my question is a little bit deviated from your talk.
Okay.
DNA fingerprinting. So it is also now law has accepted the result of DNA fingerprinting. So earlier it was this technique was developed in 1990s, and earlier it was not accepted. Now it
Yes.
is accepted due to its accurate result, and so many crimes has been solved by using this technique.
Yes.
So, what is your opinion about this? Why it was not accepted earlier?
See, say for example, if we understand the criminal jurisprudence, criminal justice system, there are two things. Uh, if you argue that the mobile which I possess, if you argue that okay, you are the owner of that mobile, at present whatever the mobile I'm using, if you argued that,
Yeah.
okay, you are the owner of that particular mobile, right? Then in that case, you are a complainant and I am an accused. So my question is that it is whose right to prove, it is whose duty to prove the case. Whether you ask me to produce the case or it's your duty to produce the bill and all the things.
Yeah.
It's whose duty to produce the bill and the ownership
Claimant should be produced.
claimants. Yes, absolutely. Always a claimant or complainant should produce the evidence against the accused.
Yeah.
One cannot ask accused to prove his or her innocence, right? This
Yes.
is the criminal case. Now, there are two kind of cases. One is civil, one is criminal. If in any civil cases, if a claimant has proved his case 70% and opposite side has proved his case 30% in a civil dispute,
Yes.
then who is going to win? The person who proved his case 70%.
70%. Yes.
Right?
Yes.
So in a civil case, the weightage thing is very important. Weightage of the evidences are very important, but not in the criminal case. In the criminal case, complainant has to prove his or her case beyond any reasonable doubt. So even not 95 or 96%, he has to prove 100% of his or her case. It's like a leg before wicket decision. If umpire has slightest doubt that it was the batsman was playing some forward, or it was slightly leg, or it's not on the line, or it's the bouncy one, then that benefit of doubt always goes in the favor of batsman. It
That's
never goes in the favor of bowler, right? So same thing happened in a criminal case, as you rightly said. This kind of test, this kind of methodology, was not very accurate in the past.
yeah.
So if it's not accurate in criminal justice system, we cannot rely on that things, and we cannot punish anyone on the basis of that.
Okay, sir.
So that is the reason why these things are now, even in genetic case, like there was very popular case in the state of Gujarat. It was a basically rape case, and there was a fetus, or not fetus actually, there was a miscarriage of that lady happened, and genetic test performed that time. I'm talking about somewhere around 25-30 years. So that time genetic test was not 100% sure. Though the result was positive, but it was not 100% sure about it. So during the cross examination of that person, who the expert who performed that genetic test, he admitted in the classroom that it's not 100%. So if it is not 100%, it's not accepted in criminal justice system, right? It must be accurate. Otherwise, if it's not accurate, there must be a strong corroborative evidences to support that. Then it's okay. But if there are not strong corroborative evidences are not there, so only on the basis of that scientific result, we cannot hold anyone liable if it is not 100% correct. I think I answered your question.
Yeah. Thank you, sir.
Okay, so thank you very much. Thank you, academic staff, college, especially Dr. Jagdish Joshi, Dr. Preeti Mayani, and my very good friend Rishi Bhai. Thank you very much for giving me this opportunity to interact with so many intellectual persons, faculties. So thank you.